Hey, hello everyone. Welcome back to what is the final tutorial for topic 7, the last vestiges of the exceptions to indefeasibility, the volunteers exception, and a quasi exception, or for some reason it's in the exceptions topic, the compensation regime. Before I go any further as well, I'd like to pay my respects to the people of the Kulin Nation, from whose land I join online from today, and I pay my respects to the elders past and present. Uh, Got our wonderful sponsors yet again, Gilbert and Tobin, Cause Chambers Westgarth, Clayton Utes, and King and Wood Mallisons. Oh, no, I've gone too far. And yes, I've forgotten the academic integrity statement for this week, but don't cheat. Um, what's the statement? It's along the lines of I'm useless compared to your lecturers. So yeah, go to your lectures and stuff. Don't cheat. You don't want to fail a subject. I don't know if that'd be helpful. Um, and it, presents a problem for admission too. So get your head in the game if you're thinking about cheating. I know I actually need to talk about this slide. Uh, so the volunteers exception. This is about whether registered volunteers can claim indefeasibility of title upon registration, and the practical consequences of this are quite clear. If they can claim, the volunteer can rely on sections 42, 43. Those are the main indefeasibility provisions, of course. I think there's more. There's 40 to 44, isn't it? But anyway, 42 and 43 are the main ones. So they can rely on those to take free of all unregistered interests on the land, subject to other exceptions. Um, and if not, they can't rely on indefeasibility. The volunteer cannot have better title than the transferor and are subject to the same encumbrances, and that's Rasmussen. So that's a traditional Victorian approach, and I can highlight the Rasmussen, like how the effects of it practically with a bit of an example. But start thinking about the policy considerations behind why uh, uh, an, a volunteer should not get into feasibility. Um, you know, it, it it would be quite an easy mechanism for a registered proprietor to defeat or hide assets if they can, because if you're a registered proprietor, you've got an unregistered mortgage against your property, some bank, uh, you know, didn't register their mortgage, which happens all the time because it's an expensive exercise registering, I think. So, the registered proprietor who's subject to the mortgage might just, you know, divvy off the property to his nephew, not tell him anything about the surrounding circumstances of the transaction. The nephew's a volunteer, and he then registers. Like, should he get into feasibility in that situation? Because it wouldn't it be too easy for the registered proprietor to just defeat the claim of the bank and then pass it on to someone else by passing it on to someone else? So think about that. That's definitely something the courts have in mind. But anyway. Uh, the traditional approach in Victoria is that volunteers do not get into feasibility, and it, that's taken as a matter of statutory interpretation, which I think is informed by the policy considerations because it's not the most convincing thing in the world, I don't think. Um, Hence why New South Wales have categorically rejected the Victorian approach. Anyway, uh, Section 42 itself does not distinguish between bona fide purchasers and volunteers. So that's, worth noting. However, other relevant sections refer exclusively to bona fide purchasers, suggesting indefeasibility does not attach to volunteers. Um, yeah, that's the approach. I think it was taken in King and King. That would have been in the late 1800s or very, very early 1900s. Um, and it was since backed up by the Victorian Court of Supreme Court in Rasmussen. Uh, now, this is, yeah, very important distinction. Um, so if you take the Rasmussen approach, say I have property, what do I do? Assign it to you, the proverbial listener. And then I say, actually, I don't like you much. And I'd never say that. And I'm going to Gonna go transfer it to my nephew, the volunteer. Off you go. Oh, just take it, mate. If volunteers do not get into feasibility, you, the listener, who has an equitable interest after I've sort of sold it to you or assigned it to you, let's say I sold it to you, that makes more sense. I sold it to you. Um, you can press your claim against the volunteer, the nephew, because he, quote, does not have a better position or is subject to the same title that I'm subject to. So I'm subject to your claim, in personam. Uh, I've sold the property to you, you can enforce the contract against me. And because volunteers don't get into feasibility traditionally, the nephew is effectively subject to the same contract that I am. So he has the same title as me. Whereas if he does get into feasibility, you are you're going to lose a property. So the the consequences are relatively significant. Um, so yes, sorry, I think my internet just passed out. Um, but yeah, where was I? I was going through, yeah, the consequences. So when you get on an exam, um, maybe I should be telling you this after I finish the volunteers exception, but I'm not going to. I'm going to do it now. This is completely unsettled. Uh, some people think it's settled because of the Victorian Court of Appeal and Zechary, but it's not. So you should go through both circumstances and highlight the differences as you're doing it in the exam. So, one analysis for volunteers getting into feasibility and one analysis against it getting into feasibility. I did that in my exam, and I don't think, yeah, it didn't, yeah. Anyway, I think it's worthwhile. Um, Again, as I was saying before, the New South Wales position, uh, yeah, the New South Wales courts have rejected the Victorian position. I think from the 1990s. I think it was 1993, 1992. I think they rejected it in Grigich versus ANZ Bank. Remember? Uh, I think maybe that could be a bit rare. I don't know, but I think it was Grigich. It might not have been. Anyways, it was in the 90s. So New South Wales is very positive that volunteers do get into feasibility. Um, However, is there a changing view in Victoria? So again, we have the traditional approach that volunteers do not get into feasibility. The High Court in Farrer Constructions, you'll remember that case from Equity. Um, that subject with three topics. What was it? It was about knowing receipt, knowing assistance. I think it was knowing receipt. Farrow versus Sadie. Yeah, some guy transferred property or to his wife and then their kids. Yeah. So you can see how the volunteer exception sort of came up there. Um, but they make a remark in Obiter, and if you go read the case, I think it's just one paragraph you have to read, and by paragraph I mean a sentence. It is truly quite isolated. Um, it's not one of those sentences embedded in another paragraph. It's by itself, and it looks really lonely on the page. I don't know, um, but that's relevant. I'm not sort of personifying, giving a personal feelings to a paragraph in a high court judgment. I think the fact that it stands alone like that, um, and isn't really related to the discussion, uh, sort of in this sort of set of paragraphs, the subheadings, if you will, uh, where it appears that they make that comment and it doesn't really make sense that it's there, um, which I think academics challenge its authority on the basis of that. They said, it's very unpersuasive obiter. In fact, they almost treat the High Court like they were inebriated, like they didn't mean to say it. I don't know. Um, but I'll tell you who does wholeheartedly think they meant to say it. It's the Victorian Court of Appeal in Zechary. typical. They agreed with the point that Farrow was allegedly making, the court in Farrow was allegedly making, and they say, uh, yes, volunteers do get indefeasibility. I can't remember if they expressly say it. I think they do, and they know they do. They cite Farah, but regardless, like that they say that because the entire discussion in Zechariah, as I talked about last week, is about uh, in personam, and if because the wife Marguerite in Zechariah was a volunteer, if the traditional approach in Victoria was applied and volunteers didn't get indefeasibility, there would have been no need to discuss in personam because Nagi, the son, could have simply just enforced his trust that he had against the husband against the wife because the wife received the title from the husband, and if the traditional approach applied, the wife could not have better title than the husband, so she'd be subject to the trust automatically. Um, you know, she had no protection from a prior equitable interest. So clearly, the case does stand for that authority. That it does sort of change the approach in Victoria. Doesn't really talk about it, which is interesting. Usually, when you're overturning lots of law, the cases, the judges will go through the history of the old law, the subsequent cases that have sort of relied on that position, the debates in other jurisdictions about why that law sucks, the old law sucks, and why they find problems with the old law, and then they'll change it. But there's none of that here. They've just gone cold turkey. Um, but nonetheless, it's the Victorian Court of Appeal. Quite a high authority. So um, you have to apply this. Um, because there's nothing authoritative in the High Court. There's only Obiter, and well, yeah, the highest authority we have on this is the Victorian Court of Appeal, and that's the highest authority in Victoria. So there you go. But the Premier, um, compensation, a rather sort of exhilarating part of the course, I'd say. Uh, Again, here's my favorite point about the course. Indefeasibility provides much needed commercial certainty for lenders. It does. And efficient dealings with the land. And of course, it can cause hardship. Um, you know, all three of those things appeared in my policy question on the exam. You're talking about the broad objectives of the Torrens system. Uh, so again, about policy, if you get a question, it's going to come down to like, does it make things more efficient? Does it cause hardship? And the thing that you need to keep in mind about hardship in this context is that the legislature hasn't created uh, a rule, a body of law of indefeasibility and title by registration. They haven't created that. And then after that, a bunch of hardships arisen and they're sort of, oh my God, oh, they've done it on purpose. They knew the hardship was coming. So they've got a compensation scheme. So I suggest to you, if you're going to sit there and say, oh, this indefeasibility system is, I don't think I can swear here. It is seriously messed up. You know, it's a crazy system. It's awful. It denies human rights and dignity to registered proprietors of land. If you're going to say that, uh, deal with the fact, which I don't think you should say that. Deal with the fact that there is a compensation regime that significantly reduces the hardship. Um, so I'm a massive fan of the Torrens system. It's good to be practical. I think the benefits of the Torrens system outweigh the costs. Uh, and the costs are compensated for out of the Consolidated Revenue Fund of Victoria, the Treasury. And it's a very, very generous compensation scheme, which we're about to go through, as in it's pretty hard not to be entitled. Um, and let's go through that now. But this is a bit of policy for you. Like all your policy questions should be coming back to those sort of core ideas. Efficiency, because remember the old general law system, you have to look through the deeds. Christ, imagine being a property lawyer back then. I wonder who would do that. Um, you know, those are efficiency, security for lenders, which is not a bad thing because if you guys want houses, you're going to need to be getting debt and lots of it. So, yeah, the lenders need to be secure. So, come back to those things and then talk about compensation objectively. You know, all right, Marguerite loses her house, not the Marguerite from Zachary, because she was actually unconscionable apparently. But yeah, okay, all right. Yeah, your mum loses her house. That's because of indefeasibility. That's terrible. Especially if she really likes the house. Um, but you go to the Consolidated Revenue Fund and you just buy something. You get the money. You buy something new. You know, a lot of you are from the eastern suburbs, so it's possible that in that case that you'd be getting 3-4 million from the Consolidated Revenue Fund. It's terrible. You know, maybe if you're really attached to a particular lot in Turak and you lost it, that would, yeah, you would sort of cry breach of natural justice. But anyway, the first step to establishing your entitlement to indemnity, um, yeah, you need to prove these. Uh, this is not hard. I mean, not hard to qualify and also not hard for your exam as well. Section 110(1) provides that any person sustaining loss or damage by reasons of paragraph A to G shall be entitled to indemnification. Here's my usual caveat: read all of them, but B to D are the most common. B allows you to apply if you've suffered loss by amendment to the register, which is, yeah, everything pretty much. C allows you to apply uh, those suffering loss by any error, omission, or misdescription of the registration, which is like very much like has someone at the title office said you own less land than you do, I don't know, or messed up the boundaries of your land. But then they add this haymaker in there, or the registration of anyone else's proprietor, which again, just yeah, incredibly broad. So it's the same as B basically, with the addition of that. I don't know what it's doing there. The Victorian Office of Parliamentary Counsel, I think that's who drafts them. Nightmare. Have some coffee, guys. Go back to sleep. Section 110D allows those suffering loss from payment or consideration given to any other person on faith of the register to apply. So we'll see an example of this towards the end, but if you see the register and it's clear, and you say, "Oh, buying that because it's a clear register," as everyone would, at some point you are relying on the register when you're making a transfer of land. Um, and it turns out, that there's a problem with it, or that the person isn't indefeasible and you're buying a bung title. I don't know. But yeah, if you rely on the title, on the folio, and it turns out to screw you over, you can claim. So these are the most common ones. Yeah, not difficult. So if you're a defrauded mortgagor rather, and the bank registers their mortgage and it completely screws you over, you'll be relying on B, right? Or C. Um, Restrictions on the right to indemnification. So this is important. Section 109(2)(a), any loss, damage, or deprivation occasioned by the breach of trust, whether express, implied, or constructive, cannot be indemnified for. Yeah. So, if what you're losing because of indefeasibility is a trust interest, and you can't enforce it, say, I've got a trust with you, and then I give it to the property to my nephew, um, you know, and he registers, say he pays me $10, or volunteers get into feasibility in Victoria now, let's say, he'll defeat your claim, and you can't go off to the Consolidated Revenue Fund to claim because what you'd lost was an interest under a trust. Now, the reason why you can't recover for breaches of trust, it's a good question. I'm not sure. I don't know why implied or constructive aren't there, but for express trusts, it'd be something along the lines of not the Parliament not wanting to make the Treasury responsible for losses caused by the express trust, which is basically a wealth management scheme. Um, you know, the taxpayer should not be made responsible for any loss suffered under Gina Rinehart's $5 billion trust or whatever. Um, you know, it's a private scheme. Maybe that imply that maybe that's what's sort of going into it. I'm not sure. Uh, Implied or constructive, perhaps it's just too hard to conclusively prove it. It's too easy to fake. I don't know. Anyway, that's just more of a. I don't think I've seen that one come up in the exam, but just be aware of it. Uh, Second, whether the claimant or the agent causes or substantially contributes to the loss. Okay, well, this one's a bit more relevant. Yeah, Section 110(3)(a) provides that no indemnity shall be payable where the claimant, his legal practitioner, or agent caused or substantially contributed to the loss by fraud. And then here we go. We've got an important case. Uh, yeah, Fairless versus the Registrar of Titles. Um, okay, so Fearless was the proprietor of two properties and engaged Duran to do construction work for him. Duran, I think that's his name. Duran duped Fearless into transferring the fee simples in both properties to him. So yeah, I'll provide further context. Fearless is an older man. I think he's old, and he's engaged. Yeah, he's engaged Duran to do construction work for him, as you do. Uh, and Duran's come to him with a document where it's like, sign off on this construction work, boss. But yeah, he's actually just presented him with, with two uh, executed or on his end executed transfer documents for the properties. So, I mean, yeah, Duran's a smooth criminal, probably wanted by Interpol or something like that. Yeah, just what a guy. I think it's funny. So, and then even more bizarrely, the registrar it actually is the notional defendant, uh, um, the notional defendant in the case, and they seek to deny Fairless, who's like 80, I think, any compensation. Um, so they argue that Fairless was negligent in failing to check over the transfer documents, and even a casual read would have revealed they were transfer documents. Now, I'll foreshadow that the court rejects that argument. I think that is ridiculous. Uh, and the reason why is so funny. Uh, it I don't know. The courts they're great and stuff, but like you can just tell when they want to come to a decision, don't you? They then go they go and say the court found that Fearless was not fraudulent, sorry, not negligent as he trusted Duran. What? They had an established friendship of some sort. Yeah, they decided the court decided no, this guy's getting the money. So he's not negligent. How dare you can accuse him, an old man, of being negligent? He had got documents, but because he trusted him, signed off on them, and that's okay. He wasn't negligent. He didn't read them, and I don't even know if he was that old. I think he had eyesight problems, maybe. Oh, that makes me look bad. Yeah, I think maybe he had eyesight problems, and that sort of guides the court to their lack of negligence. Okay, I'm sorry, Fearless. That was harsh. You know what? Fearless is not negligent. Good on him. But anyway, I think the more important point, really for your course, because you're not really looking at establishing negligence. It's not torts. Um, Even if Fearless was negligent, I think the fact that they went through this alternative suggests that perhaps he was, or at least he could have been. Uh, he did not, quote, substantially contribute to the loss as it was Duran's fraudulent scheme, which ultimately led to the loss. Um, yeah, so they're basically saying that, okay, all right, Fairless was negligent, fine, let's say, and he should have read the documents, which is, the idea that you read documents they put in front of you is pretty foundational to what the entirety of contract law. Anyway, uh, yeah, basically they're saying that, okay, however negligent Fairless was, Duran has just straight up, defrauded him. So that's what's caused the loss. So yeah, I mean that makes sense. Had it not been for Duran's actions, Fairless, wouldn't have been even in the position to be negligent, let's say. So, um, that's how they dismissed that first argument that Fairless was, substantially caused his own loss. Now, the next more interesting argument too. Um, so the registrar also argued that Duran, so who obviously had caused the loss, as we just established, was Fairless's agent when committing the fraud. Um, because obviously Duran had gotten him to do construction work. Sorry, Fairless had gotten Duran to do construction work for him. And you could probably say that Duran was the agent of Fairless in respect of that construction work. So he was doing it on his behalf. Um, that is contestable. He could have just been a contractor. Anyway, uh, the court basically sort of didn't pay too much attention to whether he actually was an agent because, in any event, any agency relationship was only in relation to the construction. And the scope of his agency did not extend to soliciting Fairless's signature for transfer documents. So, by giving the transfer documents and duping Duran in Fairless into transferring the property, uh, Duran was clearly not acting within the scope of his agency to build the property. That's quite clear. And you'll remember from topic 7 a couple of weeks ago, the fraud exception, bringing fraud home, that you do have to remember these concepts of agency, scope of the agency in the course of your agency, those sort of foundational ideas. Um, I can't remember if this last point um, featured in the judgment at all. Um, but hmm. Well, I definitely think it's something worth bringing up in the if you got something like this and you had to run this sort of argument. Um, Even if he was contracted to deal with, I don't know, say Duran was, given was instructed by Fairless to what's it called? Manage the transfer of his properties. Um, and he absconded or he sort of duped Fairless. He would sort of be within his scope, I think, because he's uh, you know, he's been retained to deal with the transfer of the property, and he's done it in a way that's different to what he'd been asked to, but and sort of tangentially related. Either way, remember Schultz and Colville properties that Duran is clearly acting for his own benefit, and in every sense of the word, he's often a frolic. So yeah, there's no way he would be found to be an agent of Fairless in this transaction, even if he was retained to do the thing that he'd done. Not transferring the property to himself, but if he was retained to transfer the property to someone and he did it to himself, while the sort of subject matter is the same for the agency, he's on a frolic of his own. So either way, the registrar's arguments here are really bad. I think the fact that they've gone, first Fairless cause a loss, and then second, if Fairless didn't cause a loss. Usually, when you're advancing two arguments which are sort of cannot sit together at all, it's like, oh, yeah, good luck. All right. Oh, practice problems. When Addison sees the amount granted on the mortgage, she realizes this is over and above the value of the house, which she purchased 10 years ago, which would have been worth substantially more. But being in recently recognized flood area by the council, uh, her property has decreased its value to 600,000. She comes to you concerned about what will happen to the shortfall if the property was to be sold. I believe Yeah, so the value of the property. Remember last week there was a question. Addison had a mortgage taken against her property, so right now the property is worth 600,000. So we'll go off on those assumptions that at the time the mortgage was taken out, only 600,000 was used. What was the value of the property? And I think the debt was $900,000 from last week. So sorry, I probably should have made that clearer. She comes to you concerned about what will happen to the shortfall if the property was to be sold. Advise Addison. Well, let's do it. She's wanting advice under Section 87E. What if the property is sold, as you'll see down the bottom. Advise her on this section rather than Section 87D. So, I think this came up in an exam once. If you have someone asking about the hypothetical situation if the property is sold, advise them on that section. Very good. Yeah, even though 87E and 87D are, well, quite similar. Uh, okay, so let's go through this because I said I would go through 87E when we get to it. And this is what I found like a bit difficult about the course. Okay, 87E1 says that this section applies if the land has been mortgaged fraudulently. I mean, check, that will never be an issue. If you have a question like this, yes, it's been a fraudulent mortgage. And that's not fraud within the meaning of the section 42. It's had, so you're not looking at the fraud of the registered proprietor. You're looking at the fraud of the person who's fraudulently taken out the mortgage, the fraudster, who's duped the bank, let's say. So last week it was Madison and Addison, and the bank got the title. So when you're talking about interfeasibility, you're looking at the bank's title. Have they been fraudulent? But here, you're just looking at the circumstances. Madison took the property over, took the mortgage fraudulently, but didn't tell her sister, took it out against her sister's property. That's fraud, and the registered proprietor is not party to that fraud. Check. That's never going to be an issue too. They're not going to know basically because they'd stop it if they were in the know. And C, the registered proprietor is entitled to be indemnified under the Act because of that fraud. Stop, I say. We are to go through the sections. Is Addison entitled to be indemnified under the Act as we've just gone through? Yes. She needs okay, first, yeah, she needs to rely on the qualifying sections in section 110(1) as we went through. Yep, section 110(1)(b). She has suffered loss to the bank's registration as mortgagee. This also enlivened in section 110(1)(c). So either or, probably 1B is the strongest one. Just because 110(1)(c) is really weird. Because it's got all these things about mistake, misdescription, and then, oh yeah, anyone else who gets registered and causes loss. So it's yeah. That's a bit of a weird section. So 110(1)(b) is your main one. Okay, D, the next requirement is that the land has been sold under a mortgage or charge in accordance with section 77. Here we're being asked to advise Addison if the property is sold by the bank. We're just going to assume that they're going to do it legally. Perhaps it's a bit rich to assume those things, but I think we will assume it. Okay, now the important question: what amount will be paid out to Addison for compensation? Well, it'll be done in accordance with section 110(4)(c). So basically, the tenor of that subsection is either the cost, because section 110(4)(c) expresses itself as being subject to section 110(4)(a) and B. So either the cost of the loan, that being 900,000, or the value of the mortgage property at the time the security interest was taken out, 600,000, is what you'll get. So the lowest. The bank will therefore only be able to take $600,000 from the sale, and that will discharge its security interest. The statute deems that as discharging its security interest. So no shortfall can be chased from Addison because their security interest is discharged with the $600,000 under the statute. And Addison will be able to claim the same from the bank. That's a mistake. Addison will be able to claim the same from the Consolidated Revenue Fund. So the amount that she's liable for is the amount she gets compensation under the scheme. So the Act tallies it up. So what the bank can keep is what Addison can get from the compensation fund. That makes sense. Okay. Griggs, yeah, so this is a practice problem from one of those prior exams in the exam drive. This is about inconsistent legislation. Hint. In 2000, Griggs becomes a registered proprietor for a property in Wonthaggi. Where is that? Griggs's property, along with several other farm properties, abuts land, I think that means it's next to it, on which it is being built, the Wonthaggi Desalination Plant. Wow. In 2008, the Desalination Plant Act was enacted. Section 4 provides that the first 10 meters of the land parcels that abut the Wonthaggi Desalination Plant are hereby vested in the Desalination Authority. Ding, 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 ding. You should be thinking, oh my God, which one of these two cases, two, is this like? No prize for guessing Calabro. Anyway, notwithstanding this provision, Griggs remained on the title because the Desalination Plan Act did not authorize the registrar to enter the Desalination Authority as a registered proprietor of the 10 meter strip of land. Good. Basically, this is saying, oh, the Desalination Plan Act was never amended. Yeah, cool. Uh, yep, so the Desalination Authority can become registered under the Act, and then they try to press their claim here. That's basically the tenor of it. And Lee has bought the property off Griggs. Question is, does Lee have any grounds to challenge the DSA's assertion of ownership? Yeah, so this is about inconsistent legislation, as I said. Section 4 vests the first 10 meters of land in parcels that abut the Wonthaggi desalination plant in the Desalination Authority. And this is compared to Section 42, which, if the registered proprietor, if there is a registered proprietor over that 10 meters, and that's Lee, that vests title in them. So it's completely inconsistent, and Section 4 will prevail. So this is exactly like Calabro. It's not hard to tell, I don't think. Um, yeah, so the latter act will stand. So the DS Act will stand, and Lee will have no grounds to challenge the person's ownership of the 10 meters, the Desalination Authority's ownership of the 10 meters. Um, yeah, you can rely on some of those weird statutory interpretation principles here too. Public rights will prevail over private rights. The general will not derogate from the specific. So Section 42 is dealing with land as a whole. Section 4 of the Desalination Act is dealing with 10 meters on very specific land that abuts the Wonthaggi desalination plant. So it's clearly more sort of specific. So now, what about compensation? Does Lee, I didn't ask this, but this is a little add-on. Does Lee have a preliminary requirement for compensation? Yes, he does. Um, Section 110(1)(d). He relies on the mutual understanding he was purchasing all of Griggs's land. So he's relying on the folio. So the next question is there contributory negligence? Should he have read the act and realized that the Desalination Authority can take the land? Basically, the exam answer said no. It's not someone's job to be aware of all the council's powers. Um, but yes, I think that's all. Um, you know, Thank you very kindly for joining. Uh, Please study hard, and I'll see you very soon with the topic eight seminar, and we'll move to exam revision. I'll fit some practice exam questions in there for you, and yep, it'll be good fun. Okay, all right. Have a wonderful week. See you later.